Welcome, Litigation Nation. I'm your host, Jack Sanker, along with Danessa Watkins. This is the show we talk about some of the most important and interesting legal stories of the past couple of weeks. Danessa, what do we got today?
Well, Jack, as you know, immediately after the May 30, 2024 decision came down finding Trump guilty of 34 charges of falsifying business records, I pretty much immediately texted you and said we need to do a show on this.
Yep.
It brings up so many interesting legal issues, a lot of unknowns. We're kind of in uncharted territory here. So I thought it would be interesting to scour the internet for what the legal scholars are saying about this and have our own little discussion about what we think all this means.
Fantastic. Well, let's get into it. All of that and more, folks. Here's what you need to know.
All right, so just recently we had 12 jurors in New York, all independent people, depending on who you ask, I guess. They charged Trump as guilty of 34 charges of falsifying business records, which is a felony in New York. And this boils down to a situation in 2006 when Trump and Stormy Daniels, who is a porn star actress, engaged in extramarital sex, which Trump denies to this day. And after that, when Trump was running for the presidency in 2016, his what we call former fixer, Michael Cohen, he testified that Trump approved a $130,000 hush money payment to Ms. Daniels. Cohen handled the payment himself and testified that Trump approved a plan to reimburse him through monthly payments disguised as legal work. So this is the substance of the falsification of business documents allegations. And the Manhattan District Attorney decided to elevate the case to a felony on grounds that Trump was concealing an illegal campaign contribution. So the jury came back finding Mr. Trump guilty on all 34 charges. And this was a historic outcome in our jurisprudence. This is the first former or sitting president to be tried and convicted of a felony crime. Now, this actually surprised me because thinking back, we've certainly had some characters, I guess, holding the presidency. But I did look into an opinion that was written by a Stanford Law School professor and legal historian and ethics expert, Robert Gordon. So when asked whether there had been former presidents tried and convicted of a felony, he answered a resounding no. We all usually think of Richard Nixon, who was named as an unindicted co-conspirator by the grand jury investigating the Watergate crimes, but he was actually pardoned by his successor, Gerald Ford. Thinking way back, we have Aaron Burr, who was Jefferson's vice president, that might have been charged for killing Alexander Hamilton in a duel, but was not. He was actually indicted for treason for allegedly conspiring to lead a rebellion against the Republic, but was eventually acquitted.
Didn't know that.
I know. Then another instance that probably comes to mind quickly is Bill Clinton, who faced possible charges of perjury and obstruction of justice for lying about his affair with Monica Lewinsky, but he was never actually charged. He was, however, disbarred in Arkansas. So that is actually probably the highest level of discipline that any of our former presidents have faced up until this point. Now, this brings up a lot of unknowns. I want to, though, start first with what can we expect next out of this case, because I think certainly we know that the defense team is going to be appealing. But before we get to that point, there is still a sentencing hearing, which is currently scheduled for July 11th of 2024, which happens to be just days before the Republican Party National Convention in Milwaukee. So depending on how the sentencing goes, Trump may or may not be able to attend that event. But the crimes that he is charged with, they each carry a max sentence of 4 years in prison, and those would run concurrently. So it's not like he would get 4 years times 34. They would all run at the same time. But there's also no minimum sentence. So this gives the judge a lot of discretion. He could issue a fine, he could do probation, Trump could be confined in his home under supervision, or he could actually be behind bars. So these 34 charges are all Class E felonies in New York, which is the lowest tier. The prosecutors have not yet disclosed what they're going to be asking for during sentencing, but the judge will be able to take a lot of things into consideration. I guess pro-Trump is the fact that he is a first-time convicted offender, that this was a nonviolent white-collar crime. He's 77 years old, and we expect that he will be presenting a number of character letters from friends and family to help guide the judge. But on the other hand, the judge could certainly consider the fact that Trump had numerous violations of the gag orders during his trial.
I think there were 10 contempt orders entered on this case.
I believe so. I think he ended up, didn't he get fined for
Yes, he's been fined a lot of money relative to what type of case this is, but there are 10 contempt orders, and that is proper for the judge to consider that when sentencing.
Right. So even if he is, though, sentenced to incarceration, he can ask the trial court judge or the appeals court for bail pending appeal so that he can stay out of custody while he challenges his conviction. Typically those type of hearings, they look at whether someone is a flight risk, which I think he's not, despite his money. We know that he's running for the presidency. So
where would he go?
Yeah, exactly.
Not Europe. Who would, I don't know. Yeah,
Who
Argentina.
Would take him in? Yeah, maybe. So we've got another month to see what happens at that sentencing hearing, and then after that is when Trump's team can move for an appeal. Now, the appeal process could take, it certainly will take more than a year. It could be more than 2 years, actually, depending on how far it goes up. He will appeal to the state court, appellate court, but this could eventually go all the way up to the U.S. Supreme Court, just given the issues that are involved here. So we have scoured the internet looking for everything from legal scholars to just, people off the street talking about what are the potential issues for appeal here. One that came up most often was this issue of the extent of Stormy Daniels' testimony. So during the trial, at 2 separate occasions, the Trump defense team asked for a mistrial because Daniels' testimony was just going, I guess, really into private issues that maybe...
She was given a lot of sex details.
Yeah, that really didn't have any bearing on the issues, but the judge did allow it. It's definitely the fact that she was talking about him having an extramarital affair, not using protection.
So as I understand what happened here, and this would require a pretty in-depth review of the trial court transcript, which, we don't have the time to do. But as I understand, the Trump defense team here made a standing objection to this type of testimony at the outset, probably an motion to eliminate or something like that. The judge reserved a ruling, and then Stormy went up there and testified, and they renewed their objection after the fact, at which point the judge said, sorry, it's not a timely objection, you've waived. So I don't think the judge substantively ruled whether it was admissible or not. It was a timeliness aspect, which, for those of you who are listening that try cases, you all know, absent an agreement or an order to the other way, to the opposite effect, you do have to renew your objection every time, and that's that could be on the lawyers here. I don't know.
Okay, that's interesting. Yeah, I hadn't heard about that one.
Because, by the way, if you review the actual testimony that she's talking about, I was like, how on earth did this come in? Mm-hmm. Because it's like, you don't need to talk about this stuff to convict him of a documents charge. Right.
And I think I didn't look into this one too deeply, but I think there was other information that came in that really wasn't pertinent, like his other cases, potentially, I think with Jean Carroll.
Yeah, I mean, a recurring theme of all of the Trump legal problems, and I don't know these lawyers, and I don't know, and I mean, I don't know anything about them, but I'm basing it on the reputation of some of his other representation in other matters. Is Trump hires the weirdest lawyers in America? That's just been his MO for as long as he's been on the scene. They're usually quite weird and usually have. I'm sorry, but they are just. So there's a lot of like things that happen during Trump trials that don't happen if just a normal attorney was representing him. I don't know if that's the case here, but that would be par for the course.
Like a creation of chaos situation.
Yeah, I mean, you remember the guy with the mustache and he looked like Colonel Sanders? Like, it's always someone like that. I'm sorry, but... Anyways.
Just a way to throw things and, just maybe distract. It could be that those are slim pickings when he comes down to picking his representation.
He keeps not paying them. And then his last personal attorney is in jail. So, yes, he is getting like the Looney Tune lawyers. Like, that's all he's getting. Anyways, go ahead.
All right, well, we'll see how that plays out at the appeal level. But, all right, other potential bases for appeal. And this one probably has more teeth than others. There's this issue about whether the prosecutor was direct enough about what charges he was bringing and what Trump was actually on trial for.
So this is, if you mind if I jump in on this, because you were talking about the decision of the prosecutors to charge Trump with felonies. So typically, as I understand it, this business record falsification charge or whatever is usually a misdemeanor.
Correct.
But it can be brought as a felony charge if the prosecutors are establishing that the falsification of the documents was done in an attempt to commit or conceal a separate underlying crime.
Right.
And here, as I understand it, Trump was charged with this felony level falsifying business records charges, all 34 counts of it, because he falsified records to conceal a separate violation of New York election law, which prohibits conspiring to promote a political candidate, in this case Trump himself, through unlawful means. So that is the hush money paid to Daniels, which was allegedly paid with campaign contributions. So it kind of stacks here.
Yeah.
It's interesting, though, that charge that this is like that the otherwise misdemeanors are resting on has not been adjudicated. So it's the jury had to basically believe that he was guilty of another crime or likely to be guilty of another crime before they could even get to whether he's guilty of these like felony counts, and unanimously they did.
Right. So to break it down a little bit. So I don't think there's any case law on this issue. So it may be one of the first times where a state prosecutor has invoked an uncharged federal crime, so this election fraud, and there's questions about whether that should have removed the case even from the state court to the federal court level to begin with, whether this court even had jurisdiction over the matter. But yes, it was essentially asking the jury to assume something, but it also, in doing that, didn't give, this would be the argument, didn't give Trump the due process of timely receiving notice of the crime that he allegedly intended to commit, because the prosecutors weren't so specific about it.
That's been the spin afterwards, but I mean, it's in the pleadings. Like it's the citation to the New York statute or whatever. Like it's there.
Well, I think you read the definition of that statute. I think the part that is vague is the unlawful means. So what were the unlawful means that he was using in order to, further this crime?
So here's I actually have the falsifying business records in the first degree felony statute from the state of New York here. Section 175.10 of the, Penal Code in New York. Falsifying business records in the first degree. A person is guilty of falsifying business records in the first degree when he commits the crime of falsifying business records in the second degree, and when his intent to defraud includes an intent to commit another crime, or to aid or conceal the commission thereof. Falsifying business records in the first degree is a Class E felony. So you don't have to be guilty, by the way, per this statute. You don't have to be guilty of another crime. You have to have intent to commit another crime. So that's a different standard.
Okay,
Yeah.
that makes sense. The Wall Street Journal put out an article, when was this? June 4th, so right after these decisions came down. But they kind of described it interestingly. So, quote, to recap, the prosecution involved 1, a misdemeanor elevated to a felony based on an intent to commit another crime. 2, an indictment and trial that failed to specify or present evidence establishing another crime the defendant intended to commit. And 3, a jury instruction that the other crime was one that necessitated further proof of unlawful means. It's a Russian nesting doll theory of criminality. The charged crime hinged on the intent to commit another unspecified crime, which in turn hinged on the actual commission of yet another unspecified offense. I mean, when you put it that way,
sure.
It's.
But
And again, we haven't read all of the trial hearing documents. We don't know.
Right.
What the prosecutors said, how they said it, what was disclosed to the defense team.
I fundamentally reject this premise that the defense was caught completely flat-footed when it came to closing arguments, and they had no idea at all what was going on. This is a case that they would have spent hundreds of hours preparing for. There would have been multiple pretrial conferences. I understand that that's kind of the narrative, and this is setting aside, like, we're not going to get into whether this was fair or not or whatever, but I do think that this is like, as the kids would call it, cope. They're just making people are making excuses here. I mean, I don't know. I just reject the premise outright. Yeah,
I don't know the term cope.
they're coping. It's like
like a coping mechanism.
copium.
You
What
want,
kids?
I don't know.
you're making stuff up to.
You know what I'm talking about? Okay, all right. We can cut it.
I kind of like that.
Yeah.
Sorry. Okay, our producer understands what coping is, so I
Yes.
guess I need to brush up. Okay, fair. All right, so that I think is one of the arguments that probably people have analyzed the most from a legal standpoint. But let's see, another one that definitely goes to a lot of issues of legality are the instructions to the jury. So I did look up exactly what the instructions were, and the judge said, quote, although you must conclude unanimously that the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you need not be unanimous as to what those unlawful means were, unquote. So the argument then on appeal would potentially be that in criminal court, you need to be convicted unanimously of a crime, and here the instruction was, that the jury didn't have to come to that unanimous decision. Now, this comes from a Supreme Court ruling from 1991, Shad versus Arizona. This was a murder case where it was found to violate the due process clause for a state to convict someone under a charge of crime so generic that it could be any combination of jury findings of embezzlement, reckless driving, murder, burglary, tax evasion, or even just littering, for example. When you have a jury that can find all these different aspects of wrongdoing and then issue a conviction potentially based on different findings, that is considered a violation of due process rights.
Yeah, I wonder where this instruction came from. And for those of you listening, in most jurisdictions, there's going to be what are called pattern instructions. And the pattern instructions are, for the most part, have been approved and vetted either by some, state-affiliated bar administration or by the Supreme Court in the state itself. And these are the jury instructions that are going to be used 99% of the time. They're going to be safe to use in the sense that you're not going to catch an appeal from it, and you're not really going to get many objections to it. They'll be tweaked based on the facts of the case, one way or the other. So I don't know where this particular instruction came from, if there was a pattern for it or not. But if there was, again, this is one of those things where like people may be making a bigger deal out of it than it is. I don't know. But if this is a pattern instruction, and because there's so much scrutiny on this case, by the way, this judge is going to be catching an incredible amount of media scrutiny. So is the jury. So are the lawyers and prosecutors and everyone else. If there was a pattern instruction available, I would bet my law license they used it.
Right.
But I don't know that there was for such a niche charge.
Mm-hmm.
So, yeah.
Yeah, especially when, like you said earlier, that this particular section of the code in New York doesn't usually get used as to bring felony charges.
Right.
So we'll see what happens with that potential argument. The last one I found, and I'm sure there's a ton, but one that could be put forward, and I don't think it's going anywhere, but that the gag order that restricted Trump's public statements about witnesses violated his rights. I mean,
Okay.
yeah. I wouldn't be surprised if that got thrown in the end, but I mean, that's ridiculous.
Yeah,
So.
right. Yeah.
Okay, so we will probably follow up more on, whatever happens with this appeal. But the questions that I got texted by family members almost immediately were the more fun ones, like, can Trump run for president? Can he vote? What happens if he wins? So I wanted to dig into this a little bit because these are interesting questions and, like I said at the beginning, kind of uncharted waters. But some of them we actually do have answers for. So first, can he run? Yes, he can. The eligibility requirements for presidential candidates are actually few in number. You have to be 35 years old, a natural-born U.S. citizen, and have lived in the U.S. for at least 14 years. So there are no rules blocking candidates with criminal records. And this actually wouldn't be the first time that someone that is a convicted felon and even potentially in prison has run for office. Eugene V. Debs ran for the Socialist Party ticket back in 1920, and he garnered almost 1 million votes. At the time he ran, he was actually serving a prison sentence for speaking out against America's involvement in World War I, which at the time violated the recently passed Sedition Act. So Mr. Debs did not win, but he was on the ballot and did receive votes.
And 1 million votes in 1920 is a lot.
I think it ended up being like 3%.
That's a lot.
Yeah.
Yeah.
So yes, Trump can still be on the ballot, but can he vote? Now this was kind of interesting because it looks at both where is Trump a resident and where was he convicted. So under Florida law, which is where Trump legally resides, a person with a felony conviction from another state is ineligible to vote only if the conviction would make the person ineligible to vote in the state where convicted. So, lucky for Trump, in New York, felons are allowed to vote so long as they are not currently incarcerated. So, unless he is behind bars on Election Day, which by then he will have filed an appeal of, if there is a sentence that puts him behind bars, then he can vote. So.
Oh, well, at least he didn't lose that one vote.
Yeah. Hey, it may be the decider.
Who do you think he's going to vote for?
Man, I don't know. I guess it depends on what his sentence is. All right. Next one. If elected, can he pardon himself? So this one, in this particular case, no. Presidents can issue pardons for individuals who have committed federal offenses, but this is a state law offense. So the only person that could issue a pardon for him would be the governor of New York. But, given New York is a blue state, I think it would be highly unlikely that the governor would come to his aid here.
Right.
But this does raise interesting questions for the other cases that are pending against him right now.
Like the federal election case.
Yeah. So he has one that is involving mishandling of classified documents. There's a Trump-appointed judge in Florida on that case who has indefinitely postponed the trial because he said they need to resolve questions about evidence before setting a date. So that one's not going to move forward anytime soon. But again, yes, the conspiring to overturn the 2020 election, that is currently delayed for an appeal that was filed by Trump's camp. So I don't think we'll see trials in those matters anytime soon, but it does leave that open question. If he was convicted, could he issue his own pardon?
It would be weird if he could, but I mean, ultimately, he could just resign with 1 day left in his term and then have the VP do it. You know, that's what Nixon did.
Yeah.
I mean, he didn't resign with 1 day left in his term, but yeah, he could just do that. So
right.
For the federal charges, if he wins election, he and his VP can make the federal charges go away. I think.
I hadn't thought of that angle. Yeah.
Yeah.
That is interesting.
So so. By the way, the choice of his VP then becomes very interesting.
Yeah.
And I'm sure that'll be something that is like talked about in the lead up to the election. So he's going to have to pick someone that he can count on to pardon him, which is interesting criteria.
Right, which may not necessarily be the best candidate.
Well, I mean, do you think Mike Pence would have pardoned him after January 6th? If there was a felony conviction after that?
I would say no.
Exactly. So Trump's going to be like, he's going to be looking for a VP here that is locked up to pardon. That would be very interesting.
Oh my goodness.
Yeah.
He sends out a brochure like check yes or no and number one question, would you pardon me?
Yeah.
Oh my goodness. Okay, well there's that. He also has that case pending in Georgia right now, where he's being accused of criminally conspiring to, I guess, overturn, or I think he was trying to get the election officials to do a recount or overturn the Biden win.
This was the case when he called the election official in Georgia, whose name escapes me right now, and effectively told the guy, "I need you to find me
votes, right?
Find me the exact amount of votes I need to win, please."
Yeah.
And does that amount to an attempt to fix the election?
Right. So again, that's under state law. Is my understanding. So
right.
Even if convicted there, that wouldn't be something that he or his vice president, if he took over the reins or she took over the reins, would be able to pardon him for. That would come down to Georgia's governor. All right. So another question. If sentenced to incarceration, what happens if he's elected president? I think from what I've read, most people are in agreement that Trump would likely receive a stay on his custody sentence while in office to prevent interference with his official duties of president, which I guess, are more important than...
Can you imagine if he has to wear like an ankle bracelet for 4 years?
Oh my gosh.
And like he's...
I mean, I think would he be able to leave the United States?
I feel like there would be exceptions made. That would, like, for the benefit of keeping the government functioning.
Right.
Yeah. You couldn't have, like, a parole officer, like, showing up to the UN, and being like, you've got to come back or whatever.
I don't mean to laugh because it's ultimately very embarrassing.
It's deeply funny. The more you think about it, the more funny it becomes, actually. That's the attitude I've taken.
I guess you have to. You have to have a sense of humor about these things. But, I'm just trying to find the intelligent legal conversations we can have about it because, why not turn this into a, crazy law school essay at the end of the semester?
Oh, my God. It's going to be law school hypos for this for sure. The Crim Pro finals for the next semester are going to be all about this.
For sure.
Criminal procedure. It's a class we all have to take, or most of us have to take to graduate law school.
Yeah. Constitutional law is another one. Yeah, these will prove to be good essay questions. So all you law students listening, I would say read up on your local news and scholars and blogs and get your answers ready. All right, now kind of more broadly. So what does this mean generally for our political landscape and, the issues that now the judiciary is potentially going to face? So on the one hand, this verdict is definitely a powerful demonstration that our country, that the rule of law is upheld equally against all citizens. So no American is above the law. If even a former head of state can't escape facing the music, then our judicial institutions are just and equitable and operating as they should. But on the other hand, and we've already started to see this play out in the media, our judiciary is definitely facing one of the most ferocious political attacks in its history. We have members of the Republican Party and certainly Trump himself that are directly challenging the fairness of the ruling, calling the progress rigged, and even referring to the judge as the devil. So, historically, of course, our system of justice has been accused of multiple fallacies. The one that comes to mind most readily is systematic racism, which, at times has been proven true and has led to positive change. Just a couple examples. We've had jurisdictions that have started to look more closely at routine police stops, practices of local authorities, which has improved training and focused them on recognizing racial bias and profiling. We've seen changes in our sentencing guidelines. One example would be the harsher sentences that were handed down for crack versus cocaine based on, the typical users of those substances, despite the fact that they were pretty much identical. The substances, that is, not the users. We've seen, probably even to this day, pretrial releases being granted more often for white offenders, plea bargains being more frequently offered to white offenders, even use of the death penalty. It still shows, clear evidence of racism, which I think a lot of jurisdictions are trying to address, but, the numbers don't lie. And this isn't just in southern states. I found, it was 2012, so a little bit dated now, but it was a study of Delaware's practices done by the Cornell University Law School. And it found, quote, Black defendants who kill white victims are 7 times as likely to receive the death penalty as are Black defendants who kill Black victims, end quote. So, it's definitely not a new issue having our judicial system under attack as being unfair. But it just rings a little different. Now we have this white millionaire, billionaire businessman, a former president charged and convicted, and he's using his platform to call the system unfair, biased, rigged. It just brings, a different, angle on this problem.
Ultimately, the discussion here is was this a quote unquote political prosecution? And I think that question sort of, I don't really know if that's a helpful question to even ask, because to me, of course it was. Every prosecution of anyone who's a public figure is in one way or another a political decision. And a lot of people don't know prosecutors have the discretion of what charges to bring and whether or not to bring charges in the first place. And that's just up to the prosecutors. They can just kind of go with what they feel like. There are folks that you would be surprised aren't charged for things all the time. And there are folks who, when you look at what the charges have been brought against them, you're like, holy crap, this seems like overkill. And that's up to the prosecutor. So if you're going to make that point that this was a politically motivated prosecution, I would say yes, and so what? That's every prosecution that you could think of, and by the way, the second question is that bad? And I don't know. I think I'll give you a great example that comes to mind. In Chicago a couple years ago, probably everyone remembers the Jussie Smollett incident. Mm-hmm. This was the TV actor who faked a racist attack here in Chicago. I think for attention, and in the process kind of slandered the city and the police officers, and the city spent a lot of resources and a lot of time, and there was all sorts of uproar about it and everything else, and turned out to be entirely fake. And the city of Chicago went out and hired rather than the typical state's attorneys, they went out and hired a private attorney, Daniel Webb, who is a legendary trial lawyer here in the Chicagoland area, and made him special prosecutor and probably paid him $1,000 an hour to absolutely throw the book at Jussie Smollett and charge him with everything under the sun and destroy him in trial and put him in prison. And I say, good. I think that everyone was good. That's Was that a political prosecution? Absolutely.
Yeah.
Was it good that it was a political prosecution? Also, yes. So that's a, and by the way, we did cover that on episode 13 of the show, if anyone wants to go back. So that's a separate, I think people are just missing the point there, where they're like, well, this was a political witch hunt. I'm like, okay, maybe it was, but like, should it not have been? And what's the alternative? Because wouldn't it be like a political decision not to prosecute under the circumstances? I mean, and is that good? Are you, when you have someone who is inherently political, who is involved with an alleged crime that is itself political, this is campaign contributions we're talking about, and his personal reputation, which is obviously a part of his political identity, then the decision can only be one way or the other politically. You're going to politically favor this, or you're going to politically disfavor it, and you have to choose. There is no like, well, we're just going to follow the straight and narrow, rule of law, because the discretionary part of the charges is built into the system. So, so long as there is discretion at the prosecutorial level, then the decision will always be political. And so I think that discussion isn't even worth having. You could just say, yes, this was a political prosecution, and I think that was good, or I think it was bad, and those are different things.
Mm-hmm. Yeah, no, and you do it. It's good that you explained, because I don't know that everyone understands that how much discretion prosecutors have, how much discretion judges have.
Mm-hmm.
So the idea that a party put this pressure on a prosecutor, put this pressure on a judge, put this pressure on a jury, I mean, it's just, no, that's not how it works. Biden didn't cause this to happen.
Right. I mean, these are, like, let's not mince words here. Like, these are, folks that got elected in New York. They're probably registered Democrats. Like, who are we kidding? Of course, they probably are. I'm sure the judge probably is too, because that's how you get elected in New York or any place that's majority Democrat. Like, that's just geography, Mm-hmm. That shouldn't be news to anyone who pays attention.
Right. But the concern would be trying to say that because they vote a certain way, that on the bench they're going to decide things a certain way, or in making, decisions on what charges to bring, that they're going to make. I think, to me, that's where the concern comes, in that now we're starting to paint this picture that our branches are meshing and there is no independence in the judiciary. And we already have, how many stories have we covered just in a short period of time about issues with public opinion about our judicial process, and this is just, I think, causing more alienation.
Yeah, to me, again, it's just like, it's not new that judges or prosecutors are people with political opinions and biases and things like that. That's not news to me. And I think to anyone who is shocked by that, it's like, you haven't been paying attention to everything else. And we talk a lot about on the show about the Supreme Court, for example. Mm-hmm. And, on one hand, we say all the time that we think that there's quite a bit of political negotiation happening among the 9 justices when they come together and ultimately decide something. So of course that's happening at the district court level as well. But like that is the process, and it has always been the process for the entirety of the existence of the republic. So yeah, I mean, maybe I'm being overly cynical because this is my job.
This is who you are.
And maybe, as our producer Kevin pointed out, there's a perception versus reality gap, and how the judiciary likes to describe itself, of course, as impartial arbiters of truth and justice. Justice Roberts' example of an umpire calling balls and strikes. But if you really want to get sort of my viewpoint is I just don't buy that. So and I never really have. And once you do that, it's quite freeing, actually. So now you can just approach the world as it is, and you don't have to get upset about it.
Okay, so I'm on a different side of this discussion. My concerns here are definitely that we have people who are trying to weaponize the judicial system, and my concern is that the public will think that they have more power to do that than they do. I think we need to give some credit to our prosecutors and give some credit to our judges in the fact that they take their job seriously and they uphold their ethical duties. I mean, like you said, this judge knew all eyes were on him. This prosecutor knew all eyes were on their office. I mean, they even reading these articles about the issues that could come up on appeal, I think you're right. I think they kind of embellished a little bit because there's no way that they made these grave errors knowing that the world was watching.
Yeah, I'm not saying there's no appellate issues here. Don't get me wrong, but like I doubt that it's like a routine, obvious thing that that they're going to get tripped up on here. It's probably going to be something quite nuanced.
Oh, for sure, because I mean, yeah, this is a unique issue.
And another thing to consider here is like the judges in New York and the prosecutors in New York, and I don't actually know if the judges in New York are elected or appointed. And here in Illinois, we have both, but they're often elected. So like there's a democratic consent aspect of this that is like, if you want to talk about like the political witch hunt or whatever, okay, well, ask yourself, which constituents are these prosecutors and judges responsible to? The people of New York City, who by and large, New York State rather, who by and large hate Trump. So they did do what they're supposed to do. Do you know what I mean? Like if there's margin to make these discretionary calls, it would not be ridiculous for them to sit down and say, boy, what would the people who I have been elected to represent want me to do? And like on margin, they would say, go after him. Right? Like, am I wrong about that?
I don't think you're wrong about it. I'm always hesitant to, that's such an easy argument to make, and I'm sure it's going to be made on appeal, and it's already being made in the public, sphere that he didn't get a fair shake because he was in New York State court. I just think it's simplifying the issue.
Yeah, I get it. But I also think it's like, I don't know. I think people are dancing around this issue in a way that just, I think, misses the forest from the trees, which is if he was technically guilty of these things, and and I don't know, I don't have an independent, estimation of whether he was or not, but the jury says he was, and I do have a lot of faith in a jury's ability to get through this stuff. One thing I'm not cynical about is the jury's abilities to decide facts. Mm-hmm. So, the argument seems to be, well, he might have been technically guilty of these things, but the charges should have never been brought because, that's just uncouth, or that's sort of a bridge too far for our system or whatever. And my point is, don't be technically guilty of felonies, and then go to a venue where most people hate you, mm-hmm. and don't do the felonies in that venue. Mm-hmm. I don't know, like, it is simple, but yeah. I don't know. What do you want me to...
So I wasn't going to let you go into...
Sorry.
No. I wasn't going to let you go into some of the things you read, but now it seems like it's directly on point, where you said you read an opinion from...
the New York Times. They do these amazing focus groups. It's Frank Luntz, who's like the legendary Republican pollster. I think he's the one who did the one most recently, the first week of June, I believe, right after the verdict came out, and it was just and it's the undecideds, and the undecideds that they get for these things are incredible because they are undecideds, like in the sense of they haven't decided whether they're gonna even look up who's running, so they are blank slate, and so the opinions that you get out of those focus groups are amazing. One in particular really jumped out to me is just like so far in left field, but so funny, and these are the people who, by the way, this is like probably representative of like 65% of registered voters, right? If you listen to this podcast, you are not in this group, for example. But there was an individual who said something along the lines of, yes, I think it was politically motivated. Yes, I think it was unfair. Yes, it was a witch hunt. However, he's supposed to be the president, and he's a billionaire. How on earth did he get caught paying $130,000 to a porn star? That's demonstrative of his inability to run this country. You should be able to handle a little bribe to a porn star if you're going to be president. Like it's kind of a competency test, and that's kind of been bouncing around my head for the past week. I was just like, that's actually a pretty astute observation, considering all the things white-collar criminals can get away with in this country, especially rich ones, especially probably presidents. So I don't know, unforced error, like didn't have to get caught. You know, there's no, and I think that this kind of you know, Joe Everyman on the focus group who's published in the New York Times really hits the nail on the head. Like, dude, what are you doing?
Yeah.
It's so easy to get away with stuff in that position.
Yep. Oh, okay. New York City civil judges are elected to 10-year terms.
Elected, there's some elected, some appointed.
Oh, some are appointed?
Okay.
Yeah, so it's both.
Yeah, so they have a democratic, small d democratic constituency that they're supposed to, in one capacity or another, represent. So decide whether or not you think that happened here.
Before we wrap this up, I do want to give a shout out to Ava Rosenberg. She is a summer intern here at Amundsen Davis. She's a student at the School of Journalism and Mass Communication at University of Wisconsin-Madison. And she helped do a lot of our research for this podcast. So we were just taking a quick break and chatting about what we've been talking about, and she brought up an interesting point. Ava?
Yeah, obviously I don't have all the facts on this case, and I've only heard about it recently.
Neither we. So
With O.J. Simpson passing away, and I wasn't alive during the trial, but I'm enjoying learning about it and reading it. But I was thinking about when Jack brought up like celebrities being brought to trial in the courts and how it's like political and you can't change that, and that's how it is and you have to accept it. About if it's political to charge O.J. Simpson, and obviously it was like a different case, like murder is a very different charge than a felony falsifying business records charge. But what I've read about the case, people definitely racialized it and kind of made it a point that he shouldn't get convicted because he is like a role model to the black community, and like there were very few at the time and in sports. But what does that say about our judiciary system? And even if that like that's only one of the arguments that was brought to the media, obviously like the jury made their own opinions on the facts of the case, but how that relates to bringing Trump to the stand and like what that says about our judiciary.
Right, and you also raised the point about what did the people of California want out of the O.J. Simpson trial, which I think is an interesting question too.
Well, I think the O.J. Simpson trial can also be understood as like the LAPD trial, you know, and in a lot of ways the LAPD was on trial during that, and like it's I'm not an expert, I'm not an O.J. Simpson versus the people of California scholar, but there was quite a bit of, you know, improper policing and overt racism that was uncovered and discussed at trial in front of the jury. So not that that's exactly what happened here, but yeah, the venue matters, and like the people that are in your jury pool matter, and your reputation matters, and that should not shock anyone, is my opinion. I think if people need to like consider what the alternative would be here. With respect to the Trump case, like we're going to operate on the assumption that he's technically guilty of what he was charged with, because that's what the jury said. And I have no reason to discount that at this point. If you're technically guilty of it, then your argument boils down to, but I should not have been charged because of X, Y, Z.
Usually constitutional due process rights were violated.
Sure.
Yeah.
And if that's the case, I hope that the conviction gets thrown out. You know, if Trump's constitutional rights were violated, then I hope that the appellate court, or I think it's the Superior Court of New York, I'm not sure.
I think that. I don't know. They label their courts differently.
Yeah. And then I hope that, you know, that's addressed and whatever. And I hope that he gets the same amount of justice in that regard, as process justice, as anyone else would. But ultimately, you can't be mad about a system that is inherently, and by 200 plus years of tradition, and by statutory law, like it builds into the system the discretion of the people involved in it. It's not an algorithm, and so if the prosecutors and the judges have, a 20% margin in which they can kind of go with their gut, then you can't be mad that they looked at the vibe and went with their gut here, and they find you as a defendant repulsive, or a good person that we should cut some slack to. That is the system for everyone, including Trump. And that, of course, leads itself to a lot of biases. Like you mentioned, racial biases, of course. That 20%, discretion or 30% discretion, whatever you want to call it, is going to skew hard towards over-prosecuting minorities, and if someone has, an inherent racial animus. But that, again, that is the system that everyone has had, and including Trump. So I that's what bothers me most, is this idea that he's being treated any differently than someone who was, brought in off the street with a routine charge. I don't see that at all. I think it's, in fact, the complaint here is that he wasn't treated differently. And that's, cry harder.
Well, I'm actually glad you brought that around, because I thought you were going a different way with that. But yes, no, 100%. And I agree with you. If there were, if he didn't have his due process rights, if there are findings to that effect at the appellate court level, the Supreme Court level, whatever it is, then yes, absolutely. Give him the rights that he's owed. But yeah, at the end of the day, I mean, yeah, this is the system we have. And thank you, 12 jurors, for your service, because I would be shaking, sitting in their seats trying to make this decision. And the fact that they came down the way that they did, knowing that Trump had already violated all these gag orders and was, their safety's at risk, their family's safety's at risk, and they still did their job. And so...
Yeah, I mean, I think it boils down to, if you spend the last roughly 6 or 8 years antagonizing a certain subsection of the population directly, like coastal liberals, for example, which, we're not coastal liberals, but we're in Chicago, we're, urban, whatever. But if that's your whole personality for the last 10 years, is just antagonizing those folks at the, international level as president, and just whatever, don't be surprised when they have the opportunity to get you back within the margins that they do. I wouldn't do it that way if I were him. That's just me.
You would commit your crimes in a red state?
I would not never commit a crime, but if I did, I would get away with it.
You heard it here, folks. Be a smarter criminal is the the wrap up of this show. No, this was super interesting. There are definitely still some open questions about what's going to happen. I don't think we'll know for a while. We need to see what the sentences are. We need to see what the appeals look like. We need to see what happens with these other trials that are not going to go probably before the November 2024 election, but, could bring up some interesting legal issues depending on how those wind up. So, again, this is not supposed to be a politically motivated leaning one way or another. We are just trying to bring every angle of our analysis to a highly political case. And it's interesting. So,
yeah.
All right. Well, that is our show for today. Remember to like us, follow us, subscribe on Apple, Spotify, YouTube, wherever you get your podcasts. As a reminder, we're coming out with new shows every other week, so look for us on every other Tuesday. Again, shout out to Ava Rosenberg for helping us on this show and giving her insight, as well as her amazing legal research skills. That's all we have for now. We'll see you next time.